Thank you. And thank you all for joining us. We have a great uh, panel today. Our two speakers talk about this topic, the administrative state, which has become very prominent as a legal topic, both in academia, but also in the courts over the last, I'd say, decade or so. I mean, administrative law has always been a huge topic, but it has grown in prominence, I would say, in the last decade, in part for reasons having to do with the changing composition of the Supreme Court, but also changing views at the court about various doctrines of the administrative state. So this is a very timely topic given the start of a new administration, an administration that has a lot of ambitious plans for programs and for administrative uh, uh, action. And we're delighted, of course, to have our two guests with us today. I think it makes sense to start with Ms. Little, who I think will present for about 15 minutes on her views, and then we'll turn it over to Professor Leiter, after which I will pose a few questions to both of them, and then we'll open it up to questions from the audience. So Ms. Little, over to you.
Great. Thank you very much for having me. Thank you, Catholic University Federalist Society and American Constitutional Society. It's a pleasure to be with you. As Professor Alicia correctly noted, the administrative state is an enormous topic. I would like to confine my remarks to 5 points and put them in the framework of the concerns that the organization that I work for, the New Civil Liberties Alliance, is particularly concerned with. And that's first, as we view it, the administrative state has grown into a framework that both makes law and adjudicates law. And that's a area of great concern. I'll be talking to you in a few moments about guidance and how that plays into that. Also, Congress bears a lot of the responsibility for the growth of the administrative state through its delegation of lawmaking powers. And so one of the things we're very interested in is litigating and otherwise educating the public about how Congress's divestment of that power has come to bear upon the lives of Americans. And finally, the various deference doctrines that mean the courts defer to agencies and how that plays into a situation where very often agencies not only make law, prosecute law, enforce law, but they are deferred to when there's some sort of review at the court. And that's just too much power in our view. So I'm going to focus on the 37 executive orders that were issued by President Biden in the first few days of office, because this administration is still young enough that we don't really have a lot to go on. And I don't want to make presumptions about what will happen in various agencies who may not even have a director at this point. And the first is the rescission of 2 orders. The first of them was called Promoting the Rule of Law through Improved Agency Guidance Documents. And the second is Promoting the Rule of Law through Transparency and Fairness in Civil Administrative Enforcement and Adjudication. Those are 2 orders issued in 2019 in the Trump administration. These orders had nothing to do with substantive regulation at all. What they had to do with is it forced agencies that intended to enforce guidance that they had to post it online in a searchable form so that if you were a regulated person or in industry, you could go to the website of the agency and search for guidance and have some idea of what might govern your conduct. Furthermore, an agency official had to own the regulation. There had to be signed off by someone at the agency, so there was accountability. And the second order required the agency, when it pursued an enforcement action, to articulate the legal authority for that exercise of power. And they also further had to provide the individual or business with an opportunity to respond to the claims made against them with the cited authority by the agency. Now, one thing about, and I should disclose that this was something that New Civil Liberties Alliance that I worked for had worked very hard to do. We filed over 20 petitions with nearly every federal agency asking them to enact a rule that pretty much did the same things, that forced them to articulate their guidance. If they didn't post it online, it would be abandoned. And so it would winnow out guidances that had perhaps been issued that the agency no longer wished to conform Americans' conduct to. We were very pleased when these process type executive orders went into place because it governed the conduct of the executive branch in a way we felt would be very accountable and easy for Americans to abide by. So it was extremely disturbing when those were two of the first orders revoked by President Biden. One of the things that is worth noting is these have nothing to do with substantive regulation. They go to the process. How do we regulate? Should we do it publicly? Should we do it in a way that someone who is searching the agency can follow? So that was a huge disappointment. The pretext for the rescission of the orders was that it was to aid in, amongst other things, the COVID crisis, which is absurd. The second is, and this sort of goes along with it too, the SEC, which is an agency I follow very closely, also revoked a policy that had been put into place where it allows now lower level agency officials to commence prosecutions. This is highly dangerous to have low level decisions made on prosecution. It means that unaccountable career bureaucrats can start a prosecution without there being a politically accountable person for that. So that was an area of great concern to us and disappointment. And I would be very interested to hear what the argument is against having such transparency, accountability, and due process in agency adjudication. The second, rather the third, I'm sorry, because the second was removing the prosecutorial decisions to lower level people. The second one, which is also very disturbing, is there had been a practice that had started under the Obama administration, where if the government pursued a prosecution, it could settle it by allowing the target of the prosecution to make third-party payments to other organizations. The most infamous of these was the Great Mortgage Shakedown, as we like to call it, where after the 2008 banking crisis, various banks, such as Bank of America, were told, if you make donations to La Raza or the National Fish and Wildlife Foundation, you could reduce your settlement obligation, and you get credit at the rate of, for every dollar you give these favored organizations, your settlement obligation is reduced by $2. This is a wildly unconstitutional and illegal way to settle government cases. It violates the receipts laws, amongst many other reasons. So there were three policies put into place by then Attorney General Jeff Sessions, a memo prohibiting the practice. It was put into the Department of Justice manual, and finally made a rule. And President Biden revoked those very early in the first days of his administration. Again, this is not substantive regulation. It has to do with how the government conducts itself when it regulates. And that's an area of grave concern, to remove those opportunities for what very often looks like corruption. Another memo issued on January 20th is called Modernizing Regulatory Review. One of the things that few people understand is that regulation is a hidden tax that costs Americans somewhere in the range of $1.9 trillion a year. This is not a tax that is enacted. It is not a cost that is very easy to uh, for Americans to understand and get a hold of, but it is enormous. And the modernizing executive order issued by President Biden said that when measuring costs versus benefits, that the cost benefit review process had to fully account for benefits that are difficult or impossible to quantify. That's law speak for putting your thumb on the scales of the benefits of litigation without fully accounting for the costs. And this is cost benefit analysis. Even people like Cass Sunstein have said that this is a very important way to evaluate regulation, evaluate its efficacy, and for that to be changed and modernized so that you have all this leeway in when you account for the benefits of regulation is another dangerous and concerning development. And so the fifth thing I would like to talk about a little bit is the revoking the Trump executive order regarding the border situation with Mexico. It's been big in the news. It's worth talking about today. And to sum up, President Trump and the president of Mexico had reached an agreement whereby there would be border controls in place. And it was a concern for Mexico too, because the Central American and South American and Southern Mexico people trying to get into the United States in time of COVID was a matter of grave concern. And so they had reached an agreement. That was just revoked in the first days of office by President Biden. And we see the situation that has developed there. The president of Mexico has said that these Central American and South American people who want to get into the United States are responding to the Biden administration's revocation of those controls. And they, like any other group of people, they're rational people. They believe that if a president makes a change in the rules, they can move over the border. What that has led to is a number of doubling, if not more, of people at the border, which is very difficult to control. People with COVID have been getting on Greyhound buses. Greyhound has actually sent a letter saying we can't endanger our other passengers and our employees by continuing to take people who have not been tested for COVID. And yet that is the current situation. So those are 5 areas of concern that I think are worth talking about. The general direction, of course, of these orders is that it's open season on regulation, and that any kind of brakes that might reasonably be put on the process, such as the due process and transparency regulations I talked about earlier, or executive orders that were revoked, or what seems to me to be an extremely reasonable arrangement in time of COVID, restricting border admissions, have fallen by the wayside. And I think we're going to be seeing the costs, both political and human costs of the revocation of those orders. And so what does this tell us about regulation? And I think the theme that I return to is that when you give all this power to regulatory agencies, the problem is no one is accountable. Courts like it because they can just toss a case off their docket under a deference doctrine. Congress loves it because they don't have to make the hard decisions. They can just delegate generally to regulate in the public interest, and they're off the hook for the very hard decisions that have to be made. Finally, I think that this process of defining what is a regulatory breach through guidance or other illegitimate processes, and then prosecuting Americans for that is deeply troubling. One thing that very few people know is that Americans are 10 times more likely to be hailed in front of an administrative law judge than they are to be brought into federal court. That means that an agency that is defining whatever the thing they've been they're charged with violating has been defined by the agency. They're brought before a prosecutor, by a prosecutor who's employed by the agency, and then they're tried before an administrative law judge whose boss is the agency. And surely that's a problem. Any of you interested in how all that might work out, you may be familiar with a case called Lucia versus the SEC, which was a huge administrative law case decided in 2018. And after that case was won, Mr. Lucia turned to my group, the New Civil Liberties Alliance. We represented him in subsequent proceedings. And I have a blog post at NCLA which talks about what he went through. He was actually prosecuted for a ridiculous nothing burger issue that took everything from him, his life, his livelihood, his health. And he finally had to throw in the towel. But it's recommended reading. I think it's something that you seldom are taught in law schools, and it's called Ray Lucia's Mythic Lift, and I recommend that you go read it. I think that my time's up. Am I correct, Matthew?
Thank you, Ms. Little. Appreciate that. Professor Leiter, why don't we have your response, and then we'll start our Q&A.
Sure, happy to. I want to start also by thanking both the Federalist Society and ACUS for bringing me here today. Very pleased to join you all. I was at Catholic for 3 or 4 years before I moved to American, and loved being there. My daughter was born while I was there. She, until about 2 minutes ago, was sitting across the table from me, now at age 12. So it's been a while. But I am very pleased to be virtually back. I also should say, as my comment about my daughter makes clear, that I am sitting in a crowded house with a dog that might bark at any moment and children that might pass through at any moment. So apologies in advance for that. I have some general thoughts that I would like to offer, and then I will turn to a few of the specific things that Ms. Little identified as potential topics. So first, my general points are in sort of 5 categories. I do think, it's probably no surprise to anyone that I'm taking the other side of this debate. I think we need a very robust administrative state to protect human health and welfare. Our industrial system is sufficiently complex at this point that I do not think Congress could be entrusted to do it on its own. And I do not think individual industries, individual members of society would sufficiently self-regulate. So we need some level of regulation. I will respond to one thing Ms. Little said right now, which is that I absolutely agree that regulation is a cost. It is a cost that is imposed on the regulated entity, sometimes in direct terms, in terms of dollars that they must spend, and sometimes in terms of an opportunity cost, opportunities foregone. But it is absolutely a cost. It is a cost that I think, not always, but in many instances, is balanced by the significant benefits of controlling the unregulated activity. So as I said, I think we need the government to protect health and welfare. I don't think Congress can do this on its own because of the complexity of our contemporary society. So Congress must, in my view, delegate to executive agencies. When we come to specific legislation, I would guess that there are probably places where I would agree with Ms. Little that the delegation is overly broad or insufficiently specific. But in general, the idea that we need delegation to executive agencies to implement regulations or draft and then implement regulations to ensure health and welfare, I think is a good idea. The agencies are in the executive branch. For those of you who haven't yet taken administrative law, that presents a sort of obvious constitutional, I don't want to call it a problem, but a constitutional challenge, because we are delegating some of what sure feels like lawmaking authority to agencies that reside in the executive branch, which is charged with implementing and enforcing the laws. But I do want to emphasize, and I'm going to go into some detail on this in a minute, those agencies are accountable to Congress, they're accountable to the White House, and there are many other checks and balances in place that keep the agencies broadly accountable to the electorate, even though they are in the executive branch and they're not directly elected. So I am willing to concede that our system of administrative agencies is not perfect. And, if I had been charged with identifying flaws in the administrative state, I could have come up with a long list. I am also ready to concede that this is not a system that the framers would recognize, but I think it is the best solution we have right now for ensuring health and welfare in a very complex industrial economy. So delving into the details, I want to explain two of these points in more detail. So first, why do I say that these issues are too complex for Congress to handle on its own? And then second, what checks and balances are in place to keep the agencies mostly honest and accountable? With respect to complexity, my area of expertise is environmental law. And so I want to focus on environmental health and safety regulation. And specifically, the example I'm going to use is regulation of air emissions from coal-fired power plants. The health and safety risks that face us today are far more complicated and require a deeper scientific understanding and a more nuanced cost-benefit calculation than the framers could possibly have imagined. So the decisions that government needs to make involve highly nuanced choices about how to balance the admitted cost of regulation against the benefits of those regulations and identify a way, I'm sorry, I'm getting a message that my internet connection is unstable, but you all can still hear me, yeah? Okay, excellent. Identify what the best way is to address a particular health and safety risk. So again, thinking about this issue of regulating particulate pollution from coal-fired power plants, we have two sort of benefits and two risks that we have to figure out how to balance. So very roughly drawn, the choice is between saving lives by reducing asthma cases by imposing pollution control costs on the electric companies that rely on coal-fired power plants. Those companies will pass those costs on to consumers, so there are admitted costs. Consumers will see higher electric bills. That will result in an increase in the cost of power. That will undoubtedly be regressive. Those increased costs will hit the poorest consumers the hardest. So there are benefits of that regulation in terms of lives saved, asthma cases averted, but there are real costs of those regulations in terms of increased cost of power. And there are public health and safety costs of increasing the cost of electric power, right? It costs more to turn your lights on. It costs more to live in a warm, well-heated house, et cetera. On the flip side, if we allow the power companies to continue to produce lower cost power and simply accept the higher number of asthma cases and associated mortality, that is lower cost on the one hand, but lower sort of upfront financial cost, but it's going to impose a cost in terms of medical bills and lives lost. And it's important to note that those costs also are likely to hit poorer communities and communities of color far harder than wealthier white communities because, and the statistics bear this out, we have largely located our large polluting industries in poorer communities and communities of color. So there are real costs and benefits to be balanced and a decision to be made. At a constitutional level, I would agree that we would, of course, prefer for the elected legislature to make that choice and to decide whether to impose these regulations in the first instance. But embedded in this trade-off is a very fundamental decision that I think the legislature itself doesn't want to make. It's a decision about how much each life is worth. If lives were truly of infinite value, we'd be willing to undertake any amount of regulatory cost to avoid a risk to human health, but we're not. So we stop short of perfect safety because it's too expensive. We are implicitly placing a value on human life. We're implicitly placing a value on certain lifestyle choices that are made possible through cheap power. And we need to balance those things. If we asked Congress to identify that value, I think it would be paralyzed. No Congress member could go on record saying that life is worth $1.1 million, no more and no less, or $5 million, or $10 million. But that's a calculation that we ask agencies to make every day. So EPA's current value, you can find the guidance that identifies this. EPA's current value is about $10 million per life. And make no mistake, they're making very express calculations. This regulation will impose a certain level of costs on industry to be passed on to consumers for the predicted benefit of saving human life or improving human health and welfare. So what that means is we're asking the agencies to evaluate regulations, think about how many lives will be saved, the improvement in human health and welfare, times the value of those lives, and make a decision about whether that outweighs the cost that's being imposed on industry and other players. My point here is Congress doesn't want to be asked to make that choice. I think I agree with Ms. Little that that Congress people prefer to be able to delegate, but I think we need those choices to be made, and we would rather they be made by experts at the agency who understand the science, who can do the calculation, et cetera, rather than be sort of held up in Congress, which I think would just be paralyzed, would be unable to delve into the details and to make the calculation in a convincing way, and then unable politically to make the required decision. The other point that I want to make, so that's why we delegate in the first instance. Why does that not make me as nervous as it makes Ms. Little in terms of the checks and balances? Because agencies do actually have a lot of oversight, and we have a lot of checks and balances in place. I mean, this is, when I teach administrative law, I teach it from this point of view. We have created this headless fourth branch of government. What have we done to try to keep that headless fourth branch in check, right? And we've done quite a lot. Have we done enough? Probably not. There's a lot more we could do, but we have done a lot. We have a system of White House oversight, and of course, presidential elections do sometimes turn on the big question of pro-regulatory or deregulatory, right? Reagan, to take the first biggest example, ran on an expressly deregulatory platform, won on an expressly deregulatory platform. That's the electorate speaking about its view on whether the headless fourth branch should be able to regulate. And at that time, the electorate wanted a more deregulatory framework. So first, the presidential elections are a sort of broad brush check on the unchecked executive. Second, Congress exercises a lot of oversight of agencies. So when I was working at the Interior Department, even as a deputy assistant secretary, I had the opportunity to testify in oversight hearings 3 separate times because Congress wanted to delve into the specifics of the regulatory issues that I was working on. They wanted to call me up and say, what's the evidence in favor of what you're doing? What's the evidence against what you're doing? Here's what our constituents are telling us about whether this is a good idea or a bad idea. And we heard them loud and clear. Did we always do what they wanted us to do? Maybe not, but we heard them loud and clear, and did what we thought was best. And then, well, two more things I want to identify in terms of checks and balances. The eye-opening thing for me that I think is not sufficiently in the press or sort of in the public discourse is the amount of input that agencies receive from all of the entities that they are both regulating and regulating on behalf of. So we had daily meetings with industry representatives who wanted to let us know, and they would have read our draft rules and they would have very nuanced comments, right? This specific thing that you're asking us to do doesn't work for the following reason. Likewise, we heard regularly from the local communities that would be affected by our regulation. We heard from NGOs and interest groups, et cetera. So there's a lot of public input. I would argue actually more public input than the average congressional committee is receiving from all of these groups. And so from the point of view of sort of constituent input, we heard quite a lot of it, and we really took it very seriously. So we were, working hard to make sure that we were giving equal time to folks on all sides of these issues and also responding to the concerns that we heard expressed. And then finally, the judicial oversight, I think, is important. And Ms. Little suggested that it's easy for courts to just defer and toss a case out. But I actually think courts, or at least good judges, and most judges I think are pretty good and take their job seriously, sort of dig into the details of a rulemaking record, and they only defer if the agency's choice is broadly reasonable. There's room for deference. There's some ambiguity in the governing statute. But if what the agency has done is sort of out of bounds, if the agency has made a policy choice that turns solely on the politics of the administrator, or that fully misconstrues the science, or that fully disregards some science that was in front of the agency, et cetera, then courts are there as a backstop. So I think agencies, they're not perfectly kept in check. I fully agree, but I think the checks and balances that we've set up are pretty good. So let me respond to some of the specifics that Ms. Little raised. I don't, and this may seem like a cop-out, I don't really want to talk about the immigration issue because it's not my specialty, A, and B, it feels like a human tragedy to me. It felt like a human tragedy in the Trump administration. I didn't love how the Trump administration was handling it, but I am the first to admit that I don't love how the Biden administration is handling it right now either. I don't know the right answer. I don't have wise things to say about it. So I'm going to avoid that issue, other than to say that the whole thing, it feels to me like just a large-scale human tragedy. With respect to the idea that administrative law judges are sort of writing the rules and then enforcing them in the way that Ms. Little suggested, that that there is a sort of due process problem for hailing people in front of an administrative law judge whose boss is the agency. I just want to note, it's absolutely a concern. I agree that it is a concern. The Administrative Procedure Act, as you'd learn in an administrative law class, has a lot to say about it and does a lot to set up firewalls, et cetera, to try to keep the administrative law judges neutral and separate from their agency bosses. I think those protections are important. Are they always perfectly implemented? Maybe not. They do work pretty well, I think. I just served on the transition team for the Biden administration in the Interior Department. And one of my former colleagues who knew quite a lot about how certain issues were handled at the agency is now an administrative law judge at the agency. And it was made very clear to me that as a member of the president's transition team, I had no business reaching out to somebody who is now an administrative law judge for the agency to ask him about sort of policy issues at the agency. How are those policies handled, et cetera, because he's now moved over to a role at the agency that is meant to be sort of a neutral adjudicator, and he is walled off from issues of policy at the agency. And I think that's very important. Is it perfect? Probably not, but it does a lot of the work to ensure that administrative adjudications comply with due process. A couple of other points. I agree with Ms. Little that transparency is important at agencies. I don't always agree that rules or executive orders that ostensibly promote transparency, in fact, do so. So to take one example, the Trump rule, that at first it was an executive order and then it was implemented through guidance and rules at a couple of different agencies, that was intended to promote scientific transparency. Its ostensible purpose was scientific transparency. Its actual purpose, in my view, was to really gum up the works. There were requirements, for example, that you could only rely on science if it had, if all of the data are public. That's a soundbite that sounds really good. Of course, we want our science to be public and transparent. In fact, when you look into scientific protocols for how you do human health research, often the guidance, the sort of best practices in the sciences is not to make the data public because of privacy concerns about the subjects who are being studied. So I think the science transparency rules at the EPA, the Department of Interior, et cetera, excuse my daughter sneezing in the background, were principally intended to make it really difficult for agencies to figure out what science they could use and how they could use it, and sort of gum up the regulatory works. And I'm not in favor of transparency that, I'm not in favor of rules that use a sort of ostensible interest in transparency as a way to slow regulation or keep agencies from doing what they've been tasked with doing. I think if we want to take the power back from agencies, let Congress do that. But if what we want to do is just sort of gum up the works, I'd rather we be honest about what we were doing and not pretend we were talking about transparency. And then the last point, well, sorry, two more points. One was Ms. Little made a point about side deals and whether side deals are a good way to let industry out of settlement costs. The Trump administration didn't like those. I would just note that industry tends to like them too. So often when there is, particularly in the pollution context, if an industry is accused of violating a clean water rule, for example, they can sometimes, instead of paying a much higher fine, they can instead, or ceasing doing what they're doing, they can instead undertake some sort of mitigation action, right? If you're going to fill a wetland, you can instead build a new wetland somewhere else. Industry tends to agree to those things voluntarily. Why? Because they cost less than whatever the ordinary enforcement penalty would be. So I think allowing the opportunity for those side deals can actually be a win-win. Of course, we don't want to have kind of a uniform sue and settle type policy, but when there is a clear infraction and there is a way that we could have a win-win solution that would be lower cost for the polluting industry and also benefit the surrounding community that has been suffering with the pollution, I don't see why we would take that off the table ex ante. And then on cost benefit analysis, I would just note that one reason why there's a focus on making sure that we understand the magnitude of the benefits is because benefits are often somewhat more nebulous and harder to measure, whereas the costs that are being imposed on industry are very clear and come right off of their books. So it's easy to see what the costs are. The benefits come in the form of lives saved, asthma cases averted, pollution pulled out of the atmosphere, et cetera. That's much harder to measure. All right, I've gone on too long and I will stop.
Thank you, Professor Leiter. So I'm going to, since we have 15 minutes left, I'm going to pose one question that tries to draw on some of the themes that both of you raised. And of course, Ms. Little, to the extent that you have responses to Professor Leiter, feel free to incorporate those into your answer. It seemed to me that Ms. Little's concerns about the power of the administrative state rested on kind of the combination of three major constitutional and statutory interpretation doctrines, right? Deference, so broad deference to administrative agencies by the courts under doctrines like Chevron, and as modified after Kaiser, our deference. The delegation of authority to the agencies in the first place, right? Arguably in violation of the non-delegation doctrine. And then the insulation of some agencies from direct presidential control through limitations on the removal power under Humphrey's executor. What's interesting is that all three of those areas are areas where the Supreme Court in the last few years has expressed real interest in revising the doctrine in those areas, right? We saw that in Kaiser on deference doctrines, where the court was clearly signaling, including the Chief Justice, that Chevron might not be seen in the same way as our. There's been a lot of movement against Humphrey's executor over the last few years, including in Free Enterprise Fund, Saylor Law, potentially Collins at the court this term. And then we know that at least 5 justices have come out publicly saying they're willing to revisit the non-delegation doctrine with an appropriate case. So my question to both of you is, the Biden administration has big plans, right? Regulatory plans as to what it wants to do. So you could easily see challenges in these areas coming up to the Supreme Court over the course of the Biden administration. Which of those 3 areas do you think has the greatest potential for significant changes in doctrine? And how do you think that would affect the administrative state if one of those 3 or more of them were actually revised significantly? Let's start with Ms. Little on that. Thank you.
I think the easiest for a court to change is deference, because it's a judge-made concept. And so if the judges can do it, they can also undo it. And that because one of the reasons Chevron gets so much attention is, I believe it's, if not the most cited case, one of the most cited cases in all of jurisprudence, which right there tells you that it's either great stuff or it's being overused. I've obviously fallen into the latter camp. So I think it is easier for the court to do that. But I think delegation is a close second. I think there's some indication in the Gundy case, for example, where the delegation was mind-boggling. That was a situation where you had a sex offender registry that had been put through Congress, and a lot of important things had been debated in Congress, as it should be. Who's covered, how does it affect their lives, et cetera. But Congress then punted on how you dealt with past offenders and said, we're going to let the Attorney General just decide. Whatever he says works. That was an appalling amount of authority to hand to the chief law enforcement officer of the United States. And the Gundy case, especially Justice Alito's separate opinion, I think shows that there's willingness to move on that. Also, and I'm litigating this right now, the insulation from removal. I just argued that issue before 16 judges in the Fifth Circuit as to whether the removal protections that the SEC administrative law judges enjoy are constitutional. It's a very active and vital part of our jurisprudence right now. And we are seeing, I would say, forward motion on that particular issue. So, all of them are active. I think I gave them in the order it would be easiest for the courts to start implementing or restoring these doctrines. I think all 3 areas are ripe for judicial improvement.
Professor Leiter?
So I think I largely agree, except with which direction I think would be an improvement. But I agree that all of these doctrines are fluid, and that the court has strongly signaled an interest in reevaluating. I think I probably would order them in the same order that Ms. Little did, in terms of how fluid they are and how likely they are to change. I can tell you for sure that those NGOs that challenged Trump era rules and are now dealing with the Biden administration are scrambling to figure out how to keep those cases out of the Supreme Court for exactly the reasons that Ms. Little identified, in terms of, worrying about deference doctrine, worrying about the non-delegation doctrine, et cetera. On deference, I'll say one quick thing, which is that it's not clear to me that courts making these policy choices is all that much better than agencies making these policy choices. I can see why we might want Congress to make more of these policy choices, but we get there by strengthening the non-delegation doctrine. If we keep the non-delegation doctrine as vapid as it now is, and all we do is remove deference, then at the end of the day, the entity making these policy choices is the judge. Because by definition, with respect to the Chevron 2 step, you've already gotten past the step where you said, did Congress clearly speak? If they clearly spoke, that is the end of the matter. We're already sort of at step 2 of a deference decision, and we're deciding whether what the agency did was broadly reasonable. If we're not going to defer, the only other choice is for the court to decide what it thinks the right policy choice is. And I don't find that to be better, because they're even more insulated from any kind of accountability. I think I would probably agree that we could stand to have a less toothless non-delegation doctrine.
For a quick response,
Please.
I do absolutely agree that delegation is part and parcel of the analysis that you need to look at, and that you certainly don't want courts making policy decisions. I think a court can instead say, this is actually a decision Congress would have to make. One other thing that came up in the discussion that I'd like to point out, because this was news to me a few years ago when I started really looking into this, and that's the idea that agencies have a lot of expertise. When I studied the background of the SEC administrative law judges, not one of them, not one, had any background in securities law at all whatsoever. They had been Social Security judges. One had been at the FCC. The other had been, military law judge or something like that. But the point being that what I discovered is that the expertise emperor has no clothes. And that when you go and really examine the background of a lot of the people who are making huge decisions about the lives of Americans, they don't possess expertise. And we need to be far more critical about that. And the other aspect of expertise is, even when an agency does have expertise, for example, in clean air cases of the type that Professor Leiter has been involved in, typically an agency will prefer the views that expand its power. That's just human nature, it's political nature. And so does it adequately take into account dissenting opinions on that expertise? And I would argue that you could make a strong case that the agency expertise is not a balanced one in the typical agency.
Thank you both for that. We're going to go to student questions now. I actually have to bow out because I have class at 1 o'clock, so I'm afraid I have to drop off. And I think Matthew will take over in terms of moderating the student questions. But thank you all for having me here. And I very much enjoyed the conversation, which was very enlightening. See you all.
Thank you, Professor. Catherine, you got the first question.
Thank you. Thank you both for this discussion. I've really enjoyed it so far. My question is comparing Ms. Leader's claim that she had earlier about human rights and how if we really did care about human lives, we would be willing to address most regulations with the traditional historical perspective of, paraphrasing Ben Franklin, if you're willing to give up essential liberty for temporary security, you deserve neither. Where does personal and individual liberty enter this conversation, especially in view of a lot of human rights concerns?
Should I go first? I will go first. I think that the courts, of course, are the backstop that protects human rights. And I think government certainly can overstep. I think I might draw the line in terms of what is overstepping in a different place than Ms. Littlewood, but when it happens, I absolutely think we need the judicial branch as the backstop and the Bill of Rights and beyond, the amendments, et cetera, to check the power of an uncontrolled government. So I think human rights, well, individual liberties are very important, but sometimes infringe on other people's human rights. I think, we live in a crowded world, and so I certainly can't exercise all of my rights unchecked without stepping on the toes of my neighbors, et cetera. And I guess I think agencies are there to rein me in when my actions might cause harm to others. When the agencies reining in oversteps, that's where courts serve as a backstop. So I guess I'll stop there. See if you have thoughts as well.
Yeah, I do have some thoughts on adjudication is something I've looked very closely at, so I will use this as an example. But we all have a right to a jury of our peers under both state and federal constitutions. That right is taken away from us under most of these administrative law schemes. It's very one-sided. For example, the SEC can sue you either for an ALJ or it can get a jury trial in federal court, but it has the option. You don't. You are bound by their selection that you are going to be tried before an administrative law judge. You can't have a Seventh Amendment right in the federal Constitution that can be extinguished by the agency's choice. That means it has a right and that it does not give you. And so it has turned your right into a mere option that is can be taken away from you. And that's just one example. Administrative adjudication is full of due process problems, no rules of evidence, insufficient. I mean, your rights of appeal to the circuit courts are illusory for many reasons, including that the record has already been shaped by someone employed by your prosecutor. And in those situations, I have to say that I don't see an argument to be made where your liberty, which means you can't have things taken away with you without a jury of your peers deciding, or you have a right to call witnesses on your own behalf without the prosecutor interfering with that. I don't see how those impinge on anybody's rights. I mean, I suppose technically jurors spend time on a jury they might not otherwise have to spend, but that's a civic duty and a cost that I think we should all be willing to bear so that each of us has equal rights to secure justice under the terms the founders set.
Thank you both. I think before, we're about to close here in a minute, but just wanted to ask both of you for a quick 30-second kind of soundbite of what is kind of the strongest argument for or against the constitutionality of the administrative state before we close. And I think that will be the last question of today's event. Thank you both. Professor Leiter, you can go first.
Okay. The strongest argument I have is that we have 3 branches of government and Congress can delegate its authority to whomever it chooses to. It delegates in a lot of different directions. And in this particular case, it has delegated to agencies in the executive branch. And as long as that delegation is kept in check through some version of the non-delegation doctrine, congressional and White House oversight, public outreach to regulated entities and to the public, and judicial oversight as a backstop, I see no constitutional problems. Now, some of those lines have not been drawn in the place I would draw them. And I personally think I agree that we could strengthen the non-delegation doctrine to ensure that Congress isn't giving away too much of its legislative authority.
Well, I locate the same issue as the strongest case against the administrative state, and that's Article 1, Section 1. It says all legislative power shall be vested in the Congress of the United States. And state constitutions do the same. And yet both state administrative agencies and federal administrative agencies get these broad delegations of power. And so, as I said, you're 10 times more likely to be brought before an administrative law judge. Americans really don't understand this. Everybody thinks if you go to court, I mean, it's either a state real court or a federal real court, but it's not. It's 10 times more likely to be an administrative law judge where your powers to have that decision reviewed are so limited, and his or her powers to exert authority over you under uncertain rules, or even rules that get made up at the proceeding, and again, read about Mr. Lucia, is quite disturbing. And so I would rest the strongest case against the administrative state to be in Article 1, Section 1 of the Constitution.
Thank you. With that, I think that concludes today's event. Thank you so much, Professor Leiter and Mrs. Little, for participating, and on behalf of FedSoc and ACS, thank you everyone for taking your time out of your day to participate and join us. Thank you all.
Thank you all. Much appreciated.
It's great fun to do this. Thank you.
Yeah, I enjoyed it.
Thanks, Matt.
Thanks, Tabitha.